on the council's website. I'll introduce us first of all. I'm Councillor Hunt, this is Councillor Martin Smith and Councillor Clive Towsey-Hinton. This is Craig Alcock, beg your pardon, not the scrap dealer, from the legal team to make sure that we do everything properly. First thing we need to do is, the applicant, Mr Vidani and supporters, and the two licence holders, Aaron and Carolyn Cowley, beg your pardon, and supporters. First thing we need to do is elect a chair.
Yes, I'd like to propose that Councillor Hunt chairs this meeting today, please.
I'd like to second that.
Beg your pardon. Second item, there are no apologies for absence. The third item, I'd like to move, please, as a correct record, the minutes having been circulated for the meeting held on the 4th of October. So I propose that. May I have a seconder, please?
Yes, I'll second that.
Thank you, Councillor Smith. There are no declarations of interest. So moving on now to the substantive item, which is an application for a review of the premises licence at B2B Events, Lime Lane, Woods, Arnold, under the Licensing Act 2003. I'd like to invite you, Mr Vidani, to make your case.
Okay, thank you. Before I start, would the panel like a transcript of what I'm about to say? It's your choice. To help, yeah?
Yes, please. Thank you. For completeness, thank you. We've had this as part of the bundle.
No, this is just purely a transcript of what I'm about saying.
Right,
to
okay,
say, yeah.
Thank you.
Just so you've got a record if you need it.
Thank you.
Okay, so I'd like to thank you for accepting my request for a licence review. It's effectively on behalf of quite a number of neighbours, but obviously I'm the sole spokesperson on this occasion. The objectives of this panel, this hearing, as you mentioned, are to ensure that operations of the licensee must ensure that 1, the prevention of crime and disorder, 2, public safety, 3, the prevention of public nuisance, and 4, the protection of children from harm. As I understand it, those are the key issues that you'll be looking at. And in addition to that, the Human Rights Act of 1998, Article 1 of the First Protocol, states that every natural or legal person is entitled to the peaceful enjoyment of his possessions. I and the neighbours believe that the licensee has failed on all of the above, and hence my request for a review of their licence. So I'd like to go through each of those one by one, and starting off with prevention of crime and disorder. It is the council's responsibility to ensure that the licensee is not put in a position as a result of the licence that they issue whereby they can allow crime and disorder to occur. This is why such stringent restrictions are, and quite rightly, are put on by yourselves and are applied to the licence. In my request for review, I've already asked the committee to establish whether the strict requirements of the licence issued have been met for all events since the licence was issued. Whilst I'd like to thank the council for providing me with a limited number of records forwarded on to me at the 11th hour and 59th minute from B2B, I would like to point out, and it should be noted, that it is actually the responsibility of the party disclosing the information to ensure other parties have copies. And since I, have not received anything at all directly from B2B, I am asking the question whether their latest submission, which was sent to me via Craig, is actually admissible. We didn't receive nothing directly from B2B, purely forwarded on from Craig. So I don't want you to answer that now. I'm just raising that as a matter because when I sent an addendum, I talked to Craig and he said you need to send a physical copy to B2B, which is what I did by recorded delivery. So I'm just raising that as an issue which I have a little concern over. Okay. But I'll work on the basis that it is admissible because I will make reference to what they sent. I'd be interested to know whether the Council has ensured that the licence requirements have been met by checking noise records and other data for events prior to what has just been supplied to them. In particular, I note that the only noise data supplied is from the last festival event, which was after you yourselves, the Council, had intervened as a result of numerous noise complaints. Further, for this last event and for events prior to this, I'd like to ask the Council whether you have been provided with any risk assessments or indeed any proof of CCTV recordings, record of door supervisors, and whether 3 months' notice was given to the authorities before any of the festival events, not just the last one, but all preceding that, all of which are required by the licence. I'd like to add also that there were altercations between security and some of the neighbours, and whilst one neighbour did call the police, unfortunately the police failed to respond. So that's what I wanted to say initially about prevention of crime and disorder. Next item is public safety. B2B have been operating at the site carrying out activities such as axe and knife throwing, as well as shooting for some years knowingly without planning permission, which does not demonstrate a suitable degree of consideration for the laws of the land. I accept this point about planning permission. I'm just trying to say that any responsible organisation should respect the laws of the land, and I don't think that's been adhered to. I've submitted a sample of posts here confirming that the events were poorly managed from a public safety point of view, and I've seen myself drunken youths at the entrance of which is actually wholly unsuitable, as already discussed under planning, but that's a separate issue. Having events such as axe throwing run by an organisation that has proven itself to be poorly managed next to a rehabilitation clinic, alcohol rehabilitation, drug rehabilitation, does bring into the question of public safety to mind. It does concern me whether the licensee has a public liability insurance cover for an organisation that carries out dangerous activities when serving alcohol on property without planning permission, with both an enforcement and noise abatement orders in place. Is this sensible? With access to the venue being under question by the Council, I find it surprising that such events were allowed to proceed, considering that the licence requires that access will be maintained for emergency vehicles on property under their ownership. I went past, this isn't in the transcript, but I went past and it was chaos outside. And the thought of an emergency vehicle trying to get access would have been a nightmare. Sorry, that last sentence isn't in the transcript. Next item, prevention of public nuisance. The licensee has held outdoor cinema and festivals and was subsequently prevented by the Council not to run further festival events due to the complaints received and due to public disorder and the unacceptable levels of noise experienced by neighbours. Subsequent, you yourselves, i.e. Planning Department, put a stop on any future festivals and issued a noise abatement order. Such actions, in my opinion and our opinion, clearly demonstrate that B2B are not a suitable organisation for holding such events. An enforcement order has subsequently been issued to remove all buildings and stop their operations. I also believe that the licence hours of operation in a rural greenbelt location between 9 o'clock and 11 o'clock, 365 days a year, is absolutely ludicrous. To be able to serve alcohol, hold music music events for 365 days a year between 9 o'clock and 11 o'clock at night, it's dreadful. Really, really bad, that. And they could potentially hold cinemas, serve alcohol, and have live music between those hours in a rural greenbelt location with numerous neighbours around. Herein also lies a direct contradiction. Since B2B do not have planning permission to operate on the site, they are limited to the 28-day permitted development rule. Surely the licence should be consistent with this. I know there's discussions about planning, but it is a question to yourselves that the two should be consistent. Finally, prevention of children from harm. The licence currently allows the serving of alcohol when events such as axe and knife throwing occur. This is ludicrous in the vicinity of young children, especially during the maze operations when there are many young children present. B2B have already demonstrated that they've been serving alcohol to children, which is unacceptable as per the online posts supplied, which you should have copies of, and as confirmed by the drunken underage youth seen at the entrance to the site during a festival. Human Rights Act. The council will be aware of the numerous noise complaints submitted by neighbours. Clearly, a peaceful enjoyment of his possessions has not been the case. And this is further confirmed by the vast list of complaints submitted to the council from B2B under the Freedom of Information Act. You should have received that. Yeah, okay, good. Absolute vast number of complaints. So, Human Rights Act isn't being adhered to. And to finish off, I've already referred the committee, and I know what you're going to say, but I'm going to say this anyway. I've already referred the committee to the planning application and enforcement order at Lime Lane with my review for request. Although this is not for planning considerations, and whilst festivals have since been banned, it does give the background history of the site, which clearly demonstrates that the licensee has not conducted itself in a poor, that it's conducted itself in a poor manner. And this is just a side note, which I want the hearing just to bear in mind. I know you're not going to comment on it, but please refer to the Baby P case in Haringey Council, whereby departments within a council did not communicate to each other, and it was decided that that contributed towards the child's death. So I think that the two departments should communicate with each other, but that's, I accept, you won't discuss.
Need you to stay on track, please.
Yes, okay, I'm just making a point that I think the two departments should speak to each other. And but what I'm also saying is that in my request review, I referred you to the planning application, but that was not for planning considerations, but for the behaviour of the licensee, okay? That's the reason I referred you to the planning, not for planning reasons. B2B events have clearly proven on numerous occasions that they are not able to manage events and their business in a safe and secure manner that complies with the requirements of the licence issued to them. Hence my request for a review of the licence with a recommendation that it's revoked. And that completes what I have to say. Thanks very much. Thank you.
Thank you, Mr. Vidal.
Shall I turn my microphone off now? Yep.
Do you want to respond to those?
Yeah, I can do just quickly. I should touch on the planning and the Baby P case. I know you're aware that the panel can't consider planning permission status as it's not relevant to the licensing objectives. I appreciate your frustration. Unfortunately, they are two completely separate regimes, legislated in completely separate ways. The way the legislation is worded at the minute, they don't go hand in hand. Perhaps they should. I think that's a moot point for another conversation. But as far as the legislation is at the minute and government's intentions from that, they're two completely separate regimes. So that's just my response to those points.
As I said, just to reiterate, the reason I referred to the planning in the request for review was not for planning considerations, just to give you the background to the site history. Okay.
Understood. May I now invite questions from B2B to the applicant, please? Do you have any?
I'm just quite intrigued as how you think we don't have public liability to start off with. I mean, that's one sort of thing. I think your actual understanding of what a premise licence is, you just don't really understand the difference between it. I find that it's quite a regular sort of normal thing for a business to actually hold a premise licence 365 days a year. That's just one of my major points sort of there. I mean, like, you mentioned about the complaints that we've actually submitted. So 130 complaints received, right? Okay. The main three complainants, there's three of them, and we're presuming. So customer 1 actually submitted 11 complaints. Customer 2 submitted 81 complaints. Customer 3 submitted 14 complaints. So customer 1 with his 11 actual complaints, 7 were related to the festivals, 3 were related to the cinemas, okay? Customer 2, who was number 81 physical complaints. It's okay, you're saying there's 130 complaints received. 81, 11 and 14, doesn't take too much to add them up. So customer 2, who actually put in 81 complaints, 60 actually relate to planning, 8 relate to the festivals, and 8 relate to the planning and the festivals themselves. I'd also like to sort of say, if you actually have a look at the letters of support that we actually got, which were quite a few actually, for us to actually keep the premise licence, one of them was from the actual police that actually state about crime and disorder and how there isn't any, and from her point of view and her chief constable, that actually there is no problem with what we did, also that they're actually happy to work with us continuously moving forward. You say about emergency access, we actually had the priory access, which if you'd actually had a look at the EMP, which was actually submitted and actually signed off by Gedling Borough Council, for all 4 festivals, it was actually agreed that that was acceptable. Anything else you can think of?
No, only that I don't know of a bar that doesn't.
Yeah,
serve
sorry, yeah,
alcohol and not
that's
allow
true as well.
children on
Yeah,
site.
so every single 90% of every single rugby club, football club, leisure centres, all have bars. There's also a bar in Nottingham that does axe throwing and has a bar on site. So to turn around and say that it's not acceptable for a business like ours to have a licence because there's children on site, I just personally don't get where you're trying to come from, to be fair, apart from wanting to tick that box.
And keeping children from harm, we actually have Carlton Academy that come on site at least 3 or 4 days a year, separate days, that will bring 200 or 300 children to us for activities.
We're also
So
an
you're not-
alternative provider for Nottingham County Council as well, where we have looked after children that come on site. So to actually say that we're actually endangering children is ludicrous. I'd also like to see your proof of where I am serving underage children.
Excuse me, you're coming across in a quite,
No,
sorry, no,
it's
in
really
quite an aggressive way. I don't know
Yeah,
whether you're
no.
aware
No,
of
no,
it.
sorry, no,
if you
but-
could just tone it down
No,
a
no,
little bit, it would
absolutely.
be
But that
appreciated.
personally, to
Understand.
me,
Yeah,
that,
all right.
that is a
Yeah.
very, very personal attack. I
Okay.
think
But I think as
don't
well with like...
understand how personal this actually is. I've held a personal licence. If you read my statement that I've submitted,
All right, calm down.
for many years, I've worked in many pubs and bars, and I actually do know how to run and manage a bar. And to say that I'm serving underage
All
children...
right, Aaron, calm down.
No, I know, but I'm sorry.
I know, and it's very...
And to say that we don't have CCTV...
Yeah, do you want to finish your statement?
Yeah.
Are we?
Sorry.
Sorry,
Are we at the
sorry,
end of
sorry.
that?
Sorry, I don't mean to...
That-
Yeah, no, I'm sorry.
It's my intention that everybody has their say,
Yeah,
but that
sorry.
it remains civilised,
No,
and
of course.
that nobody comes away from here feeling that they've not had a fair crack
Yeah,
at the
yeah,
whip,
no, of
as it
course,
were.
of course.
But
I
I
don't
don't
know
want this to get repetitive
No, no, of
in
course.
any way. Okay, thank you very much. Would your witnesses like to make their cases at this point?
Please.
Okay. Could you introduce yourself, please?
Yes, my name's Jenny Higgins. I'm a resident of Gedling Borough Council. Good afternoon. Thank you for allowing me to express my support for Back to Basic Events Limited in this premises licensing review. I've already submitted a letter in support, and my comments expressed in that letter still apply. What I'd like to add, however, is that as a local resident, I've known the owner of Back to Basic Events Limited and his family for the last 7 years. And during that time, I have found them to be of good character, reliable, honest, and extremely hardworking. In setting up the facilities at Lime Lane, their ethos has been to ensure that they provide value for money family entertainment in a safe and secure environment. I have never known them to cut corners or veer from their personal and professional integrity at any point. In fact, I would say it has been my experience that they have always go above and beyond to ensure that every T is crossed and every I is dotted. Whatever activities they have undertaken at the premises, they have consulted with the relevant experts and official bodies to ensure public safety is paramount and the operation of the premises is controlled at all times to minimise any impact on the surrounding environment, complying with the local licensing strategy, Licensing Act and rules and regulations. I don't make any of these statements lightly, nor would I make them at all if I had not witnessed them to be true. I visited the site on many occasions and seen the care and consideration that Aaron and his staff take in setting up the events, communicating with their customers and ensuring they gather feedback at the end of each visit. I have never heard any customer express any dissatisfaction or concern with the facilities provided or the manner in which the events have been run. Aaron personally walks the site on a daily basis to ensure there are no hazards, and in fact in wet weather I have known visitors to be turned away if they are not wearing suitable footwear, not something that any business owner would do lightly. The staff working across the site are well trained in all aspects of health and safety and the rules and regulations that govern the provision of alcohol and the facilities on site. ID is regularly checked before serving alcohol and is only sold to those customers that are attending site to engage in one of the activities on offer or whilst their children are enjoying the facilities. The busiest time of the year for the site is between mid-July and October, whilst the rest of the year there is limited activity, mainly consisting of children's parties and children's forestry education, or indeed providing opportunities for the fire service to run training exercises and likewise guide dogs for the blind. They operate almost exclusively between 9 a.m. and 5 p.m. with the exception of a handful of evenings throughout the year. I've never witnessed or heard of any issue with the selling of alcohol by Back to Basic Events Limited on site, nor any activity run by Back to Basic Events that has created any concern for public safety, put any children at risk or resulted in any nuisance, crime or disorder. And therefore, in my opinion, to suggest that the licence should be reviewed seems to be a vexatious and fabricated time-wasting exercise with no evidential substance to support such a review. I think it's clear from the applicant's approach and inaccurate commentary in his application that this is merely an attempt to create hyperbole to undermine Back to Basic Events Limited. And if we are honest, is little more than a fishing exercise, as it's clear from the number of questions asked in his application. His commentary constantly references objections to a change of use planning application which is currently under appeal and contains hearsay references rather than evidence to support his application to review the 4 licensing objectives for the premises licence. I do wonder if the applicant could be somewhat confused as his residence appears to be much closer to Ramsdale Park Golf Club than the Notts Maze, with the golf club being 374.13 metres from his home and the maze being 1.41 kilometres. Finally, Aaron Cowley has worked incredibly hard to build his business with integrity and professionalism, taking on feedback from his customers with the utmost consideration to the public, local residents and businesses and his staff. Any individual that works that hard would never jeopardise his business and career by putting at risk his personal licence. Thank you.
Thank you. Second witness, would you like to go ahead, please?
Hello, Lorraine Brown, Calverton Parish Councillor and Gedling Borough Councillor for the Calverton Ward. This information is in support of my previous document that I submitted. Jane Walters and Mark Stanley of the police have both stated that they have no concerns over crime and disorder and public safety at the Maze. If there were any concerns, these would have been highlighted in the Safety Advisory Group debrief. I live in Calverton and have not experienced any noise from the Maze. I do have regular disco, live bands, firework noise from a wedding venue in the next village. Whilst this can be quite regular and loud, it is part of the wedding venue experience and one I don't feel worthy of complaining about to ruin somebody's special day. The Maze held 8 outdoor film evenings, starting at 8 and finishing at 10, with all visitors off-site by 11. This is far less than the nearby golf course events programme with disco on live bands, which is much closer to Mr Vidari than the Maze, but he doesn't complain about this venue. I have been to events at the golf course and in the summer the doors and windows are open, allowing attendees and noise onto the site. It has been stressed several times that the contract with the outdoor concert group has been terminated, therefore no more concerts will take place. This was as a result of issues with the company and neighbours complaining about noise levels. This has now been addressed. Mr Vidari also highlights the protection of children on site, but all children on site are accompanied by parents, guardians and/or organised groups who have the relevant risk assessments and parental consent in place. I am, however, concerned about the protection of children on site and was shocked to be told that a drone is regularly flown over the site during events to film children, vulnerable adults and children on site. This has been reported to the police as a serious safeguarding issue. I would therefore recommend that there are no changes to the current licence agreement. Thank you.
Thank you, Councillor. Procedure's been slightly unusual in that we've heard from the applicant first. You were supposed to question, but you actually made your case, I think. So that's all right. I didn't like to stop you mid-flow. So although it's not to the letter in the bundle, everybody will get to say what they need to say. So could I move on? We'll go back to as it should be. And can I ask the members if they have any questions of the applicant, please? Would you like to just go ahead?
Thank you for bringing this forward, which you're perfectly entitled to do. And officers have decided that you're entitled to bring it forward. If the officer decided it was a frivolous complaint, we wouldn't be here today. It's not really a question to you, it's really a question to Craig on behalf of officers at Gedling Borough Council, because you've mentioned the 4 objectives of licensing. Comments really, please, from council officers in terms of the things he's mentioned: crime, public safety, public nuisance, and protecting children. Have our officers got complaints, concerns?
Like I say, obviously my role is to ensure the correct process is followed, so I'm certainly not going to answer or address any of the comments raised, because it certainly wouldn't be correct for me to sway the committee in any way. Yes, they are the 4 licensing objectives, and Mr Vidani has raised issues to address each one. As part of the licensing consultation period, so following the request for a review, there is a consultation period which followed, and what I can say from that is that the licensing officers do consult with the relevant authorities, so police, environmental health, there are 8 in total. I won't list them all, but they do send the fact that there's been a review to all of those authorities and requests for comment. Any responses to that are contained within the bundle, so you'll see that there hasn't been one from environmental health or any other relevant authority other than the police. Yes, I mean, that's what I have to say on those points. I hope that's addressed your questions.
Do you have any questions of legal?
No, not legal.
No?
I mean, as far as we're aware, we've been speaking with Craig all the way through it.
Sorry. Okay, is Mr. Boyd allowed to speak? Yeah.
Didn't comment in the consultation period, did you? I don't think you did. It's not included in the bundle. Okay, so in terms of the bundle, so everything's sent to licensing, and then it comes to us after that consultation period. So I don't know. Yeah.
4 or 5 that were
That didn't go
submitted
out,
that
yeah.
didn't actually, yeah.
My concern is it's not been provided to me in time. Now, I'm not saying it wasn't provided in time. I think for fairness, it's not formed part of the bundle, so Mr Vidani hasn't had a chance to witness it, neither have the members. So obviously I do apologise if it has been missed by the licensing team. I think for fairness today, unless all parties are in agreement to allow it.
With the chairman's indulgence, could I just pick up on a few points?
I'm not content with this, Councillor Elliott. I'm going to ask the applicant whether or not he's happy for you to be heard, and if he's not, I'm going to revert to what the advice I was given by legal. There are a lot of witnesses already, a lot of testimonials within the bundle, and I think it's only really fair to ask Mr. Vidani. Yeah. Is that okay with you?
Yeah, no, I'm not happy for a couple of reasons. First of all, there was one of the neighbours who wanted to send a bundle sent it into Craig, and he was told that it was after the submission date, and therefore that was not included in today's hearing. So I think it's fair is fair. That wasn't included and rejected by the council for the hearing. And secondly, as I mentioned earlier, what I said is I never received anything directly from B2B in terms of their latest information, which they should have done, like I sent my additional information by recorded delivery to them. I never received anything from them. And personally, as I understand the rules of the hearing, that information should not be admissible, and therefore I don't think there should be any further comment.
Thank you. In that case, then, I will say that prefer you not to speak, Councillor Elliott. Can I, before we move on, could you answer that thing from the first...
Yeah, so...
About notification, please.
Of the additional information?
Yes,
Yeah,
please.
so as you're aware, Mr. Varney, you provided additional information last week, I believe it was. Whenever it was, you provided additional information and you were advised to circulate that information, and B2B Events also provided information a bit later. I was aware when I received the information from B2B that it was unlikely that it would get to you in time, as we certainly hadn't released an email address for you and I didn't feel it appropriate to do so. I circulated that information to you as I circulated your information to B2B as well, just to ensure all parties had the information prior to the hearing. I mean, you did mention this earlier. You have also addressed that information in your representations. I'm minded if we go down the route of it not being admissible, then also part of your admissions weren't admissible. So. To me, yeah, I mean, I appreciate that perhaps you've not received it directly from B2B Events, but you did receive it prior to the hearing. I appreciate it last minute, as that was the quickest we could get it circulated. Yeah, that would be my view on it, that it would be admissible, and both parties have sought to rely on it as well.
It was more a point of order than anything.
Yeah, no, and I agree with, like you say, there was representations that came in after and they weren't, and for B2B Events, perhaps it's been missed by the licensing team, but for clarity, I just think it should, I'm just explaining, it should be treated as if it's being presented today. All parties aren't in agreement, so I do apologise, but I think the correct process has been followed.
Thank you. Your supporters with you, did either of you put a written submission in, and would either of you like to speak if you had done? No?
Just myself. I wasn't aware they could put a submission in, so.
Thank you very much. If we may, would you like to present your case? And please try not to be repetitive. Do you have anything further to add? Because given that the first two elements of the debate ran into each other, before I give Mr Vidani a chance to do the final summing up.
That one of the letters that you did receive was from Ray Butler. He's actually one of the closest neighbours to site that's actually commented on this, and his letter does state that from his point of view, he's never actually experienced any sort of problems from ourselves. When it came to the actual, if you actually have a look at the noise readings that we actually submitted for you, if you actually have a look at the festivals, if you actually do, so if you actually have a look at the 24th and the 25th that we've actually submitted, if you look at our licence, of course, which states that we're allowed to go, well, not over 15 dB over a 15-minute period at 1 metre from the nearest dwelling. So for both of them last festivals, the first two festivals, I do also have the readings here. We just didn't submit them in time, but I do have them here. We had a personal gentleman that came and did it for me, who is a sound engineer that did the first two festivals. We actually then upped our game after that, and the second two festivals were monitored for, I think it was from the 23rd to the 29th continuously by Savills, which of course are an extremely reputable company. They came along and they set up a noise monitoring system at the closest dwelling, which would be Whitbarn, which was 57 metres away from Whitbarn's entrance. Okay. If you have a look at the 24th and the 25th, you'll see on the right-hand side is the baseline. So that was set up and took from the 23rd all the way through. If you actually have a look at the 24th itself, and then actually the 25th, you'll see that there's only 1 point in the 24th that we went over by 0.6 of a decibel. So throughout them whole two festivals, and to say that it was 57 metres away from the nearest dwelling, we were actually well within the legal limits of our licence to run them two festivals that we did. And also from the legal representation that we've had, the average, what was it? A change of 1 dB is imperative to the human ear and would need at least 3 dB or over to actually be registered by an ear.
To make any difference,
So there's that. I don't know what else we've really got, really. I think genuinely the information that we have sort of submitted, I think is quite substantial. I think that we do have a lot of personal support. I do genuinely think that this is a vendetta and it is something against us, and they are trying to, because we are currently going through a planning appeal at the moment, this is another way of just trying to sort of drive the knife home. And again, I know that that isn't relevant.
Yep,
just
just mind your language, it's a bit
But
emotive.
of course, I actually sort of understand the licensing a little bit more. So yeah, and again, like what I've said, I've worked in bars for many, many years. I've held a personal license for years. I've been deputy managers. So to say that I would be running a poor ship or not know the consequences by yourself and by the police and different authorities, to say that I'm not a trustworthy person, I find quite personally offensive. But again, that's a different matter.
Can I just ask a question? I know that when Craig sent us some information earlier on when this process was taking place, we've been told that as Mr Vidani's requested the review, it's for him to prove to the committee that his complaint is relevant to the licensing objectives and how those objectives are negatively impacted by the premises. May I ask what evidence you have?
Apart from four Facebook posts that you've submitted.
Just surmising?
We've already had that information in the bundle and in Mr Vidani's application.
Right, because speaking
it is all there.
I can answer part of that in my summing up if you like.
Yes, okay, thank you. Panel, do you have any questions for the licence holders, please?
No, I think the role of council is to protect the public, and quite rightly, the concerns have been raised, and there was concern about public liability, for instance, and making sure that members of the public who attend your events are fully covered by, just in case something goes wrong. And I think the applicant suspects that things are likely to go wrong and may have gone wrong in the past, which obviously you refute. Public liability, you touched on that. Can you give us an assurance that you are fully insured, that members of the public are safe on your site?
Absolutely. So we have £10 million public liability, £5 million staff liability.
Yeah.
Can't think, not staff, but employees, thank you, employees liability. We also have all of our risk assessments are updated every single year by a competent person.
We have CCTV on site, 24 hours. Of course, we can't provide evidence of that.
I have 40 days worth of continuous recording, which is available at any time by any authority. You're more than welcome to come along and have a look, including the police. But from a public liability point of view, I mean, if it's something that you even want to see on my phone, I can bring it up right now and show you.
Thank you. Anything further?
Well, just finally, you've spoken about festivals and perhaps future festivals or lack of future festivals. What are your plans?
So we're not doing any festivals, and this has been put out in all of the planning application that we've already done. We're not applying for festivals. It's something that we genuinely, as a business, over the years, we've slowly increased, like every single business does. You try new things, you do different things. From our sort of point of view, and it's got nothing to do with the planning or the three people that are sat opposed to us now that's made us come to this decision. It is just genuinely that we, as a company,
it's not for us.
It's not what we want. We are family friendly. We are a maze. We're an outdoor activity event and site, and that's the sort of line that we'd like to go along. So from our sort of point of view, we're not looking at any festivals. We wouldn't be looking at putting on any festivals, and the good people over there have been told this quite a few times all throughout the planning application.
But no, the answer is we are not looking at festivals. It is not anywhere on our radar.
Thank you. I think we've come to the time where it's for you to sum up, Mr Vidani.
Yeah, I'm going to try not to repeat what I've said already, but
we'll haul you back if we stop wandering down the planning route.
We've just had a discussion about festivals. We all are aware that the council have prevented and stopped any further festivals going ahead by this organisation. It still allows, under the licence and the current licence, the ability to have cinemas, live music, serving of alcohol between 9 o'clock and 11 o'clock, 365 days a year. Okay? That's one of my concerns, which I've already highlighted. We are concerned for the future. based on the previous behaviour of the applicant, which is what important and one of the major points I'm trying to get across, we have concerns for what will happen with the licence as it currently exists for the future. It gives a massive opportunity for live music, cinemas. Incidentally, by the way, the Ramsdale Golf Club, as quite rightly, is not that far away from us. In 12 years of living there, never had an issue. As soon as they started the cinemas and the music festivals, big issue. So, but anyway, that's that. So, we have concerns for the future based on the previous behaviour. I did also say previously that all the data they've submitted is purely for the last music festival, which is where after the council had got involved. I'd like to know whether noise measurements were taken every 30 minutes as required by the licence for all previous events, and CCTV recordings and all the other risk assessments which he mentions for all previous events, and the 3-month notice given to the authorities for all previous events. That's one of the points I want to reiterate. In my opinion, in terms of children and youths being drunk, I can only quote what I've seen myself at the gates and indeed what you've seen on the post that I sent to you. So it's my word against anyone else as I understand that. I think to sum up really, the very fact that the council has banned the festivals in future, there is a noise abatement order in place, and the number of complaints from neighbours pretty well says it all. I just want to make sure that the sort of behaviour we've seen in the past and the risk, the possible risk with the licence as it stands, with the activities based on that behaviour, do not occur in future. And I think that summarises it. Thank you very much.
Thank you for your summary. I will just return to the legal officer.
Certainly.
A few things that you've raised there. Have we banned further festivals? Is it part of the appeal process? Is that just because it's in...
Well, the planning process is completely separate and not relevant to today. I don't believe, I'm not aware of the festivals being banned from a licensing perspective. Yeah.
No.
Yeah. Yeah.
And we would have cancelled the last two in September, but planning got involved with it, and it took so long to get through, so we couldn't plan it. We couldn't ban it. But we did have one planned for the 1st of October that was cancelled, so it's our choice.
My question was just for, was it accurate?
Yes,
they've been banned, and the answer is no.
No,
okay.
they haven't.
All right, so that's my understanding. And could you speak to the future, please, Craig, as far as what this committee can and can't do?
Yeah, I mean, obviously, what's relevant is the licensing objectives, and it's difficult to forecast into the future for members. I think they would need solid evidence that there is an issue and there is an issue moving forward. So in terms of future, it's something for, whilst it's relevant, something for you to consider. You may find it harder to find than an issue today, looking forward.
Okay, we are now going to retire, mull over everything that we've heard, and we'll be back with the decision as soon as we've come to one. Thank you. Thank you, Ben. So we resumed proceedings, and I understand that the applicant is going to wait for a full decision notice in the post, but I'll read out what we've decided. We gave full consideration to all the evidence, everything in the papers and everything that was said, hence the amount of time that it took. We have looked at the 4 licensing objectives, and we haven't seen sufficient evidence to show a negative impact on those. In relation to the historic complaint, the substantive issue of noise from music festivals, this has been dealt with by the Environmental Health Officer. He took action which B2B complied with, and assurances have been made that there won't be further festivals. None of the relevant authorities raised concerns, and there is a statutory process already for noise nuisance which can be followed should that be required. Public safety issues regarding regarding compliance with the licensing conditions. In relation to that, we've seen evidence from the licence holders that the conditions were met. There is nothing new in today's hearing to evidence that they have not been. The licensing hours that were granted are standard for licensed premises. Both parties will receive a full decision notice of the outcome from today's hearing, which contain details about appealing should that be a route that anybody wants to go down. Okay, this meeting.